Hi, all. Welcome. As you're coming in, just settle in. We'll start right away. Hi, everyone. Welcome to the webinar over the lunch hour today. A new collective agreement, now what? We're going to be looking at the 4 steps for collective agreement interpretation. My name is Deanna Kimball, and I am the Regional Education Officer for the BC PSAC region. Before we get started with the presentation and I turn it over to your facilitators, I just wanted to go over a little bit of housekeeping, and so that might help you while you're using this platform. So in GoToWebinar, you'll notice that you have a kind of a control panel, and you can open and close your control panel using the orange arrow up at the top. And for your audio choices, you can either use your microphone and speakers on your computer using your voice over internet protocol or VoIP, or you can call in using your telephone and dial using the information provided in your registration. You can submit questions and comments via the questions panel. Anytime during the presentation, somebody will be there monitoring those questions. There are handouts available in the handout section of your control panel. You'll see that, and you're able to download those. For those of you who registered more far in advance, I sent those out in advance of the webinar today. Today's presentation is being recorded and will be shared on the PSAC BC education page. And you're also welcome to raise your hand if you have a situation that requires immediate attention, and one of us will connect with you through the chat. Okay, so I'm going to turn it over to Monica, and have a great session, and I'll see you in a bit.
Thanks, Deanna. So my name is Monica Urrutia, and I'm one of the regional reps that will be facilitating this session today. I also have Sharon Barber with me. You'll see her a little bit later on. The way that we normally begin our sessions, not only virtual sessions, but also when we're back to hopefully in real life sessions, is we like to begin with a land acknowledgement. Now, this is something that PSAC has been doing for quite a long time, but it became even more important for us, especially in terms of the issues such as the Truth and Reconciliation Commission and the ongoing issues about murdered and missing Indigenous women and girls. So for me, in terms of where I'm coming from, coming to you, is that I'm actually on 4 different traditional territories of the Stolo, Musqueam, Squamish, and Tsleil-Waututh peoples. And I think that when we do these things, it's not only to always recognize the lands that we are currently on, but why we actually do acknowledgements. And that exactly is what it is. It's a recognition in terms of whose lands traditionally this was. That Canada was not created in some kind of peaceful, all of a sudden we landed here, et cetera, for people who are not Indigenous and not Indigenous to Canada. This land was taken from the First Nations and Indigenous peoples. So that's one thing I wanted to highlight, and especially because it's also been recently in the news. For those of you who are either live or work in Surrey or Richmond, you know, those city councils recently rejected motions trying to make land acknowledgements part of their policies. They have their own reasons, according to the news, in terms of why they did that. But if you're in those communities, I think it would be important to raise that question to those councillors in terms of what is wrong with recognizing the traditional territories that we are on. A practice that's very common in a lot of other places in BC and in Canada. So moving from that, I also wanted to share a statement from Jamie Mills, the Regional Executive Vice President. Unfortunately, he wasn't able to join us for this session, and so I'll just read a short message from him today that he wanted to share with you all. Hi, everyone, and thanks for taking the time today for this webinar. When workers first came together, forming unions or cooperatives, it was in order to strengthen their power and negotiate collectively with their bosses for fair wages, health and safety protections, and decent working conditions, all of which were laid out in a contract or collective agreement. The collective agreement is at the heart of our work as a union. It defines the terms and conditions of our employment, lays out our rights and obligations on the job, and it ensures fairness and equality in the workplace. That's why it's so important not just that we understand our collective agreement and what's in them, but that as new issues emerge and new needs arise, we continue to modify and improve them, making our working lives better. I'm very glad to see you learning about your current collective agreement, and I encourage you to start thinking about the next one. There will be more on at the end of the webinar. So we appreciate Jamie for sending us that statement in. He was able to share live greetings in our previous session earlier this week. But other than that, we'll move along in our session because this is a jam-packed 1 hour. As you see from the agenda screen there, we have a variety of things that we're going to be tackling today. I'll go over the objectives in just a moment. We'll talk about what is a collective agreement, just to give you a sense and a frame. Walk through the 4-step framework in terms of how we can actually help demystify our collective agreement articles, give you a chance to actually practice, and as always, try to provide some time for some question and answers at the end, and then we'll wrap up. So the objectives in terms of this session is fairly straightforward. You know, we want to walk through that 4-step framework, give it to you as a tool that you can use. We will be examining a sample article from a new article actually from several national units that recently got something into their collective agreements, and then give you a sample article where you can interpret it on your own, and then talk about how all of that relates to, for those of you going into upcoming rounds of bargaining, and some of you might still actually be in live rounds of bargaining. So the first thing that we want to do to help you get a bit more situated into our session is, you know, what actually is the collective agreement? So we have a little chat box there. You'll see it in your control panel that Deanna highlighted for you. I'd like you to put into the chat, you know, a word or two that helps describe a collective agreement. If you had a new member coming in, or if you, you know, wanted to tell people how you're protected at work, how would you describe what a collective agreement is? So some of the replies that are coming in are legal binding document, work rights, do's and don'ts for managers and employees. Any other things in the chat that you want to bring out? Okay, well, thanks for that. One of the things that I think that when we are looking at what a collective agreement is there are a variety of things in terms of the description of it. So it is a legally binding document, right? So that was one of the first things that came into the chat quite soon or early. And that's one of the things is that it's between the union, who's your bargaining agent, so the PSAC for everybody who's on the call, and the employer, right? So these are who we call the parties of the agreement. So that's who signs onto the agreement, but it doesn't mean that that's the only people who it applies to. So as you see in the second bullet there, it applies to the employer, the union, and the employees within the scope of that collective agreement. So normally very close to the beginning of the collective agreement, there is the definitions of the scope or a recognition article, and that clarifies in terms of who's covered in terms of that contract. The third point that we really want to highlight as well is that the collective agreement, while it's a legal document and it contains things as one of the chat entries said in terms of your working rights, etc. The thing is that it doesn't mention every single thing. And so anything not in the collective agreement, there's an article in the collective agreement that basically says anything not mentioned herein or within basically becomes what we call residual rights of management, right? So it's very important because then if the collective agreement is silent on an issue, you might be looking at other things that could be mentioning something in terms of that right. So it could be in legislation, it could be employer policies, if it's not in the collective agreement. And that last point that we really want to emphasize is that if there can also be an employer policy and it's still mentioned in your collective agreement. And so if there is a disconnect, your collective agreement takes precedence, right? So nothing that the employer policy can write up or create can override something that's been agreed to legally between your bargaining agent and the employer in terms of that. Okay? So those are just three kind of like main highlights of what a collective agreement is. And it's important to frame that as we walk through now in terms of what is the four-step framework. So I'll hand it over to Sharon.
Thanks, Monica. Hi, everyone. I have a little helper here today. I hope you don't mind. He should not get in the way, I don't think. So I will summarize the four-step framework, and then we will provide a few more details as we go through our example article. The first of the four steps is asking yourself, what entitlement or right does the provision itself establish? What can an employee, an employer, or a union expect to receive as a result of the article in the agreement? Who has the right, the employee, the employer, or the union? The third step is what conditions need to be satisfied for the right to come into effect. So what do the parties have to do to become eligible or entitled to the benefit in the agreement? And what obligations must the employer fulfill to give effect to the right? So ultimately, if the conditions are satisfied in step 3, then what does the employer have to do? So we're going to apply the four-step framework today in the sample article about domestic violence leave. We're going to take a minute to look at the article, and then we'll be breaking it down through the rest of the presentation. So I'm just going to end the slideshow for a moment so we can have a look at this article. It's quite long, so I'm going to read it to you as soon as I get my picture out of the way. This is Article 54 in the PA agreement and many of our Treasury Board agreements, entitled Domestic Violence Leave. And it says, for the purpose of this article, domestic violence is considered to be any form of abuse or neglect that an employee or an employee's child experiences from a family member or from someone with whom the employee has or had an intimate relationship. Paragraph A says the parties recognize that employees may be subject to domestic violence in their personal life that could affect their attendance at work. Paragraph B says upon request, an employee who is subject to domestic violence or who is the parent of a dependent child who is subject to domestic violence shall be granted domestic violence leave in order to enable the employee in respect of such violence to seek care and or support for themselves or their child in respect of a physical or psychological injury or disability, to obtain services from an organization which provides services for individuals who are subject to domestic violence, to obtain professional counseling, to relocate temporarily or permanently, or to seek legal or law enforcement assistance, or to prepare for or participate in any civil or criminal legal proceeding. Paragraph C says that the total domestic violence leave with pay, which may be granted under this article, shall not exceed 75 hours in a fiscal year. Paragraph D, unless otherwise informed by the employer, a statement signed by the employee stating that they meet the conditions of this article shall, when delivered to the employer, be considered as meeting the requirements of this article. And paragraph E, notwithstanding clauses B and C, an employee is not entitled to domestic violence leave if the employee is charged with an offense related to that act, or if it is probable, considering the circumstances, that the employee committed that act. So this is the article we'll be using as we move through the presentation. Get back into our slideshow and move along to the first of the four steps. So the first step in interpreting this article would be asking yourself, what entitlement or right does that article establish? So we can look at a number of titles of articles from the collective agreement. This is some from Treasury Board and other agreements that the PSAC has negotiated on behalf of our members. There's an article called Union Recognition, Use of Employer Facilities, No Discrimination, Variable Hours, Sick Leave with Pay, Acting Pay, Clothing, Wash-up Time, Dental Plan. These are just titles from the article. And it's a really good hint when you ask yourself, what is this article providing for me? In this case, the example, the title of the article is Domestic Violence Leave, and the simple answer when you ask what entitlement does this article establish is it gives you domestic violence leave with pay. So the second step in using this tool to interpret the collective agreement is to ask yourself who has the right or the entitlement to the provision. Monica pointed out that there's three parties to the agreements, the employer, the union, or the employee. So when reading an article, you are going to ask yourself who actually gets the right to that provision. So we're going to do a quick poll. Get ready to get asked a skill testing question. We want to know from you which of the three parties listed gains the most entitlements in a collective agreement. So who gets the most in the context of that document, the employer, the union, or the employee? So the responses are in, and survey says 91% of the participants today have indicated that the employee gets the most rights from the agreement, and that's absolutely correct. There were a handful that selected the employer, and I can understand why you might feel that, because the employer does have a great deal of power in the workplace. Monica explained that anything that's not mentioned in the agreement is really within the employer's control for the most part to dictate. But when it comes to the actual agreement itself, most of the articles you're looking at are going to be applying to the employee. So they change the fundamental rights of employees and they enhance them. And they take management's rights and they amend them so that the employee gains rights from them. So absolutely, most of the time you're going to be saying the answer to this question is the employee. But there are times you will find that the employer and the union actually gain rights as well. And it's important to determine if that's the case in the article you're looking at. So one example is the union has the right to get the names and phone numbers of all of the employees that belong to their bargaining unit. An employee would not have that right. The employer is obligated to give that information to the union, but not to a general employee. So there will be times you see articles that give the union rights and the employer rights, but in this case, most of the time, you see the employee gaining the benefit. And in this case, when we look at our sample article and ask ourselves who has the right to the provision, it absolutely is an employee. And I mean, the first hint would be in paragraph B, where it says that an employee who is subject to domestic violence will receive the leave. So thanks. We are going to be moving on to step 3, and I will pass it back over to Monica.
Thanks, Sharon. So we also, in your control tab, there also should be a tab on handouts. So one of the things in that is that that's where you can find a copy of the article. I know we sent it out in advance, as Deanna mentioned. But also in terms of this 4-step framework, I usually like to really have it in front of me when we do this in real life. We usually have it on a flip chart or in front of me, and we're taking a look at it, because then you can really see how each step follows after the other. So the reason that step 2 that Sharon just explained was really important is because identifying who the right applies to in terms of who is going to get that entitlement frames the rest of the steps. So because you've identified that for the domestic violence leave article, your who is the employee, then this will frame in terms of the conditions. So step 3 in our 4-step framework is really talking about what are the conditions that have to be satisfied by the employee, because that's who you've identified in step 2, in order to get the right or entitlement. Okay, so here, this is one excerpt of that very long article that Sharon read out for us. And you see that one of the first things when we are summarizing is that first part there, upon request, an employee who is subject to domestic violence or who is the parent or of a dependent child who is subject to domestic violence shall be granted domestic violence leave, right? So it might seem fairly obvious, but it actually is a step or a condition that you have to satisfy. So you can't just be, for example, unfortunately, you might be in the moment of it where you're experiencing domestic violence and you just want to take the tomorrow off. You still need to ask for that leave first, right? So must request the leave, one of the conditions in that new article. You must be the subject to or the parent of a dependent child, right? So you have correctly identified in step 2 that it's the employee, but one of the conditions as the employee is you have to be the subject of the person, like the person who experienced the domestic violence, or the parent of a child, a dependent child who experienced that domestic violence. It's also important to note, as we've exerted in the bottom here, that there's a definition within the article in terms of the conditions. So when we say that the conditions include having to have been subjected or a child having been subjected to domestic violence, it includes a definition of what domestic violence is. So again, here, considered to be any form of abuse or neglect that an employee or an employee's child experiences from a family member or from someone with whom the employee has or had an intimate relationship. If you don't find definitions within the article, it's also important to look within the collective agreement itself or other avenues. And we'll talk a little bit more about that a little bit later on in the session. But that's not the entire article yet. So as we go on, thanks for that, Sharon, you have to also continue to read the entire article looking for all of the conditions, which is why on the form, we really have it almost like a checklist. It has these little boxes. That's one of the reasons why I love the way that the 4-step framework form is created that way, is you read the entire article and write down these conditions as you go. And then afterwards, you take a look and see, have you fulfilled all of these conditions so that you, for lack of a better word, qualify for that right. So here they're talking it'll be granted if you're in order to enable the employee to do a variety of things. So there's a number of our conditions here. Maybe I'll have Sharon click through them so I can read them all together. To seek care and support, right? To obtain services, to obtain professional counseling, to relocate temporarily or permanently, or to seek legal or law enforcement assistance, right? So in terms of more conditions, so things that you would continue to add into your blank 4-step framework form, we basically summarize this to be, must be relocating or seeking one of the more or less of the listed support services because of the domestic violence. So that or is also very important because it means that it doesn't have to be every single one of these conditions, right? That's why we summarized it as either relocating, because that's the one there, or one of the supports that's been listed. It's not that when you are asking for this domestic violence leave that you have to be doing every single one of these bullets. We just want to make that clear for folks when you're helping members who might be accessing this new article. So let's go on to, and the other reason here is that in terms of the, still in the step 3, is to continue to read to the article, is that initial part, as you saw, was in previous paragraphs, and then there was something in between, and now we've come to the end of the article, right? So at the end of the article, it actually talks about who an employee that is not entitled to domestic violence leave. So an employee is not entitled if they are charged with the offense related to the act, or if it's probable, considering the circumstances, that they are the ones who committed the act. So in this sense, they had to take a look at the entire article. they were probably, you know, both parties, when I say they, is the employer and the PSAC, coming to some kind of an agreement of what they can agree on for this new domestic violence article for several of these national units. And they said, okay, so this is who it applies to. These are the things that they could be asking for the leave. But we also want to make clear that it does not apply in a certain circumstance to employees. So the circumstance where it does not apply is if that employee is the one who has been charged with the offense, or with all, you know, probability is the one who committed the offense. So you would add that as one of your conditions in your form. Okay, so I think that the next clip just shows that as the summary there in terms of that condition. So overall, in terms of summarizing, we just want to say that doing that, having to go through the entire article, especially lengthy or complex articles, then you'll see that in this particular article, we essentially summarize it as 4 main conditions. So if you've reached this, like if it's either for yourself as the employee, or if you're helping a member who's trying to access this leave, and you go through this checklist with them, and you see that they have fulfilled all of these 4 requirements, then we would go on to the next step, which is step 4. So as we heard, step 1, right, was figuring out what is the entitlement in itself. Step 2 is whose entitlement is it? So we've said that it's the employees. Step 3 was, what are the conditions that the employee has to do? What do they have to do to qualify for the entitlement? Now finally is, then what does the employer have to do about it, right? If you have fulfilled all of your conditions and it was the employee's right, the employer has obligations to fulfill. So that's always the question. And as Sharon explained earlier, you know, 9 times out of 10, it'll always be what obligations must the employer fulfill to give right to this effect. The few instances in the collective agreement where it's either the employer who could do something, then the question, this step 4 might change to be the union. One quick example of that, for example, is if the employer files a policy grievance against the union, then the employer becomes the who and has conditions that they have to satisfy. And if they satisfy those conditions, then it's the union who has to fulfill the how. But as we explained in terms of a collective agreement, you know, 9 times out of 10, it's going to be what does the employer have to do once the employee has fulfilled your conditions. So here, we're basically saying that, you know, the conditions, the total domestic violence leave with pay, which may be granted under this article, shall not exceed the 75 hours in a fiscal year. So when all of the conditions are satisfied, the employer is supposed to grant up to 75 hours, right? Within a fiscal year. So I had, it was interesting in the other session, I had overlooked that. So this is one of the things that's clear for different organizations. So in this collective agreement for the PA, fiscal year will mean, I believe it's April to March, right? It runs from April to March, not a calendar year. So that's an important thing to note for this particular domestic violence, and also when the clock or the leave amount basically restarts, in case, as in often cases in these things, it's an ongoing issue in the workplace. Okay. Now, the other thing that we wanted to pick up on here is that the premise from the employer side in terms of powers that they have is that they either have to accept a signed statement or advise employees that more information is required in order to authorize this leave. So if we go on to the next slide, I think we want to clarify this a bit more. Oh, I guess not. Let's go back. Sorry, Sharon. My apologies on that. One of the things that we talk about here, we always field questions about here, is that they always ask about, well, how much more information does the employer need? So for us, anyways, if you were asking myself, for example, one of the things I always take a look at in terms of providing information to the employer is twofold, right? One is that this is a relatively new article, so it's not unexpected that they might be asking for additional information at the beginning, but to also set the bar as a union representative higher in the sense that there is a context to this leave as well, right? We find it very unlikely that, you know, droves and droves of people are going to apply for domestic violence leave. We know it's a highly emotional situation. There's lots of impacts, etc. Nobody's normally gonna kind of put up their hand and wave that around. So if they're coming to the employer already, the first fact is that they're coming in order to get this leave because they need it. Secondly, we would take a look at the conditions. So that's why I'm happy that Sharon's gone back to these summary of the conditions that the employee has to satisfy in order to get the leave. Because then I would argue as a union rep that the conditions should relate to what kind of information they're looking for. So for example, if they must be relocating or seeking one of the listed supports, then perhaps it might be reasonable to say if this person was going to a women's shelter to find out what are the transition houses available that they can access, you know, maybe they can have something that's from that women's shelter, right? But we also don't want to add an additional burden onto people who are experiencing domestic violence in terms of creating barriers. Like we don't want to, for example, if they have to go and see their lawyer, is asking a letter from the lawyer going to cost more money for that individual? That's going to add an additional barrier, right? So unless there's a real concern from the employer of possible misuse or abuse, I would think it'd be important for the union to really push back in terms of how much information is really reasonably that they would need to ascertain that they're going through this. Something with the law enforcement, for example, could be that there's a police file number. That's not, I would think that's probably not as overly intrusive, but for some, they might come back to me and say, actually, that might be, because for a lot of people, they might not even have a police number, right? So it's early stages. I think it's going to be tested. That's the important thing. But our argument always is that is what they're asking for reasonable in the context of what conditions the employee has satisfied. Okay. So that's one of the things for the 4-step framework. We're going to talk a little bit later to the end in terms of how you can go into articles a bit more deeply. But I think at this point, what we'd like to do is have you actually practice with another existing article. So I hand it back over to Sharon.
Thanks, Monica. So here's the article we're going to practice with. Again, from the PA agreement, also found in many of our Treasury Board bargaining units, Article 53, leave with or without pay for other reasons. The article says, at its discretion, the employer may grant leave with pay when circumstances not directly attributable to the employee prevent his or her reporting for duty. Such leave shall not be unreasonably withheld. Or leave with or without pay for purposes other than those specified in this agreement. So this should be a somewhat familiar article for union representatives with experience, and in particular, we're seeing this article used a lot more frequently lately. If you can think of some circumstances when this article might have been used or be used, you could type it into the comments, the questions box, and we'll have a look. So yeah, someone's got weather. So inclement weather is a common use of Article 53 when someone is prevented from arriving at work because of usually snow, but there certainly could be other kinds of weather. We're seeing it used right now because of COVID, and someone got that. Someone mentioned their hot water tank blowing up. Sure, household emergencies, absolutely. If you're prevented from attending the workplace for any reason that's not directly attributable to you, you could make a claim for this. Right now, like I mentioned, we are seeing this a lot in our discussions with respect to what's known as 699 leave. That's the employer's terminology. I call it special leave with or without pay, or leave under Article 53. So let's go through the steps. Step 1, asking what the entitlement is. And again, reading the article title, leave with or without pay for other reasons. You've answered step 1. Step 2, asking who it applies to, is again relatively simple in this article, because it mentions in paragraph A that the employee would be receiving the leave. So this step, we're going to find that the answer to that is the employee when we ask who the article applies to. So step 3, take a moment to think about what conditions might be satisfied for the right to take effect. And at this point, I want you to, maybe jot down what you think the conditions are to satisfy the requirements of the article and obtain entitlement to this special leave with pay. If you have any thoughts on what the conditions are to access this article, you can type them into the questions board. What conditions must be satisfied for this right to take effect? So we actually have an interesting comment here. Would you be required to use annual leave first before asking for leave under Article 53? So I'm going to get back to that. Let's have a look at what other people are saying. That every effort was made to come into work. That is not spelled out in black and white in the article. That every effort was made to arrive at work. That we would talk a little bit more about some of the more advanced interpretation skills. But when you look at the statement that the circumstances weren't directly attributable to the employee, arbitrators have implied that that would require that there was an effort made to get to work. When it comes to paragraph B, leave with or without pay for purposes other than those specified in the agreement, people have made comments that the need for the leave cannot be dealt with under another article. So, for example, if you're sick, you would be prevented from coming to work. But because sick leave exists and it's addressed in the agreement, sick leave would have the priority. So when it comes to the question about whether you'd be required to use your annual leave first, does anyone want to answer that in the questions box? Yeah, so the answer is no. And it's interesting because when you look at what conditions have to be satisfied for this right to take effect, sometimes you actually have to look at what's not there. In the case of 699 leave, the PSAC has filed policy grievances because the employer has imposed an additional condition on employees who are trying to access this leave. So they're saying, not only do you have to show the circumstances are not directly attributable to you, you also have to exhaust your annual leave and all other forms of paid leave before we'll grant this. So in that case, the employer has actually imposed another condition that the agreement does not impose. And that is something that is a point where their rights are limited, and they cannot renegotiate the collective agreement at a whim, which appears to be what they're doing when it comes to the COVID-related leave. Oh, I should just go back one, sorry, and point out, or I think we get to the answers at the end of the slide. Okay, so let's move on to step 4. We'll ask ourselves, what obligations must the employer fulfill in this scenario? What will they need to do, assuming that the conditions are met? Take a minute to think about it. If you have any thoughts on it, feel free to enter them into the questions box, and we'll be moving on to the answers to these questions shortly. So here's some of the answers. Again, what's the entitlement? Special leave with or without pay for reasons that are not already addressed in the collective agreement. Who receives the entitlement? The employee. What conditions need to be met? The employee has to show that they're prevented from reporting for duty because of circumstances that aren't directly attributable to them. So some of the examples provided were great. Inclement weather, emergencies at home, travel interruptions, etc. There was one case where a woman was stuck in Europe for a number of months because there was a volcano erupting in Iceland, and she did receive this leave with pay for a long period of time. As long as those circumstances are not attributable to the employee, then that condition would be met. Paragraph B, the condition would be that the leave with or without pay for something not specified in the agreement. So as people mentioned earlier, the condition here is that the need for leave isn't addressed in the agreement already. Sick leave, annual leave, family leave, if your child is sick or has a school appointment, and personal leave, etc. Someone has asked if you could use this for car trouble. I mean, it really depends on the circumstances surrounding it. The employer would probably argue that it was your responsibility to maintain your car, and if you can't show that you maintained it, then the circumstances are attributable to you. But these answers will depend on the specifics of the situation. Employer obligations. So what does the employer have to do? Assuming those circumstances are fulfilled. In this case, they have to exercise their discretion, which doesn't mean just saying yes or no, based on their personal feeling. There's a specific definition of how to exercise your discretion, and it requires looking at the specific circumstances of the situation and coming to a decision that's in good faith, a reasonable decision. They must not unreasonably withhold that special leave with pay or without pay as appropriate. So they need to exercise their discretion, and they must not unreasonably withhold the leave. It's a nice kind of open article with a lot of room for interpretation and a lot of room to fit it into an individual circumstance. So that's it for me. Monica, I'll pass it back over to you.
Thanks, Sharon. So I think we're going to go into questions and comments, but before we do that, we did want to share that, this four-step framework is something that we normally present in the Talking Union Basics course. And it's only one aspect. We do much more in terms of going into conditions and different things like that. We did throw another handout in there in terms of aids to interpretation and intention. That is also helpful, especially when you're going through more complex articles. But I would say that, for example, even in the article that we walked through, so the new domestic violence leave article, if you took a look at that first couple of sentences in the article, some of that even speaks to intention, right? So I don't have it right in front of me, but it talks about how they recognize that their employees who may be experiencing domestic violence may be impacted in terms of their ability to attend work, right? So even that, without having to go into more deeper discussions about intention of the article, that would be one of the things that you could already point to in terms of why this is an important leave to be granted to employees. But the handout talks about all the different things that would help you interpret further deeply, other than the tool that we've already given you with the four-step framework. And then intention goes back to more for those of you who might have experience or have known other folks who are on bargaining teams. It's really important that when you're on a bargaining team, you take notes, et cetera, because it's one of the things that helps to inform when we're making an argument about what the true intention was between the parties when it was first negotiated. That's an advantage when it's a newer article because it'll be fresh in people's minds and they'll have that context at the ready. This is also only one part of your overall process. Like the collective agreement is just like I always like to say, is just a book unless you exercise the rights that are in there. So it's important for members, doesn't matter if you're a union rep or not, it's important for members to be able to know what are the rights in your collective agreement and how to understand them, which is why we're trying to get this 4-step framework out to as many people as we can. And also that if you want to strengthen the language in your collective agreement, the way you do that is at the time of bargaining input. So right now, Treasury Board members, I think the vast majority of the folks on the call today is from Treasury Board. They're doing a direct member-specific input drive, so you can do that right on the website. I believe Deanna will help me out and put that into the chat for folks. And you can just go in there directly. You talk about which article, what wording, and why, and you're giving the union more, basically more arguments, and be able to say, listen, we received input from thousands of our members on this particular article. They want this change. Another aspect of that is why we also have to go through the grievance process from time to time, because a lot of employers, when they're at the bargaining table, will not even entertain any changes to articles unless they say, well, it hasn't been a problem. No one's filed a grievance about it. A grievance is just a problem-solving mechanism to say, parties are disagreeing on what the article really means to them. So why don't I pause here and check in with Deanna to see if there are some questions for us.
Hi, Monica. I didn't get any questions yet in the questions box, so you're more than welcome, folks, to type any questions you have. We have a little bit of time for anything you're curious about. But one question we did get yesterday that I thought was a good kind of tool to remind ourselves about was there was a question about any types of tips or ways that you can ensure that you have all the extra related collective agreement documents for a particular issue. So like what should folks keep handy, or what other things can they do to make sure that when they're approaching an article or a specific issue that's related to something in the collective agreement, what else should they be looking at? Is there anything else? And I think that second handout touches on that a little bit, but I thought maybe this might be a good opportunity to share some of your thoughts on that.
Yeah, absolutely. The handout does help walk through that. I think that one of the things that we would always take a look at first, even when we were walking through the exercise, right, is that you look at the article. We also have to look at, is there any other related articles that are either mentioned or could be interrelated depending on the issue, right? So leave in general, there's a whole bunch of different types of leave, so you might be looking at that. If you don't have definitions within your article, then your first stop is to look within the collective agreement. So if it's not in the article, take a look at your definitions page within your collective agreement. And then if it's not there, your next frame or next step probably should be within the legislation, right, and or the regulations. So whatever legislation that employee or that unit is under, you might want to look there to see if there's any definition that will help you there. Other than that, one of the things that the handout talks about is that really it's supposed to be, the intention of the articles is how it's written in general. And so if there's not a specific definition that we can attribute in the collective agreement or in legislation, we can look into something as basic as a dictionary, right? And in terms of reasonably arguing that this word was what it was meant to be used, and that's why the parties agreed to it reasonably, let's go with that definition.
Thank you, Monica.
Oh, yeah,
we had another question from yesterday as well, but it was related to the connection between the domestic leave article that we use as an example, and I guess this person had also participated in the Bill 65 webinar in early December. So is there some sort of connection between those two? Like maybe there was just a little more clarification or some other helpful advice on that.
Sure, I might call Sharon onto the call and see if she wants to field that one.
Thank you.
Sure. Hi. With respect to the first question, Monica, something else came to mind. People can also look at past decisions, and that can be a really good way, not just to understand how the article is being interpreted, but it can lead you to other documents and policies and conditions that you might not have been aware of. So special leave, for example, there'll be tons of decisions on that on the Labor Relations Board website. And if you read one of them, it's gonna it's going to bring to your attention a lot of past decisions and policies and things. Okay, so the question on the link between Bill C-65 and domestic violence, or domestic violence leave. So Bill C-65 brought into being new workplace regulations on the prevention of violence and harassment, and those regulations do require the employer to prevent against violence, including domestic violence at work. It looks at violence, including domestic violence, as a health and safety issue, and it requires the employer to take steps to prevent against violence at work. It does not, however, that regulation does not, however, provide any benefit or entitlement to employees. It lists the employer's obligations and how to prevent against and address violence at work, but it doesn't in any way, shape, or form say that employees will receive leave or you have to compensate them for leave that they have taken, etc. So it's good to know that both pieces exist: the right to leave under the collective agreement and the right to file a notice of an incident under the workplace violence and harassment prevention regulation. So to some extent they're linked through topic, but not through outcome. I hope that was concise and understandable at the same time.
Yes, for sure it was, Sharon. There was a comment there about if there's a link or where you would find that information on past decisions. Where would you find that type of resource? I know where.
So, yeah, the F,
yeah.
Federal FPSLREB.
Yes.
I sent it to Deanna. Deanna wants to share it. I did send the link to the.
I put it in the.
But that's for folks who are under the Federal Public Service Labor Interrelations and Employment Act. Okay, so we want to make sure that for folks who might be on the phone or on the, I always say the phone on this, I guess most of us are on, perhaps are on our cell phones. If you're under the Canada Labor Code and you'd have to go to the Canadian Industrial Relations Board website. And if you're under the BC code, then there's a BC board website. So what I find nowadays is that most of them do have their decisions. They are searchable by index, by content or type. But sometimes the thing that you're looking for, just as another additional tip, is that it might not be exactly the match of what you're looking for, right? So if you're looking for something, especially the newer things, domestic violence leave, you might have to do a whole lot of searching through leave in general if domestic violence leave does not yet have an index marker or a topic marker in it. Does that help for folks? How about that link?
Yes, that's awesome. There was an interesting question. I think we have a couple more minutes, if that's okay. There was an interesting question if you want to have a conversation about the flexibility of discretion, I guess, with respect to the employer's discretion. And in that particular article, and other articles, there's the power of one or two words is very important to focus on. So do you want to have a little conversation about that, perhaps?
I can start off if Sharon wants to continue on, because I know you were saying some great things about discretion and kind of the scale of it for the employer. In terms of the sample practice article that Sharon walked you through, one of the things that's very important to read is that in that first paragraph, paragraph A, it talks about the employer may grant, right, this leave, but then in the sub-article itself, it says this leave shall not be unreasonably denied, right? So there's this, as we know, for some folks who are getting more and more familiar with the collective agreement, these may and shall things, usually have a very clear distinction, but then you put it into the same article and you're like, well, what does that mean? And then you throw in discretion in there, and so then I'll let Sharon comment more about discretion.
Discretion is a somewhat complex topic, actually, but essentially what it means is the employer can't, for example, make a policy saying And this is special leave is not the only article where they're required to exercise their discretion. But let's use that again as an example. They're not able to say, as they have currently, that people requiring leave with pay under Article 53 for COVID have to exercise all of their other leave first. That's not exercising their discretion. That's making a policy that binds their hands as to how they're going to apply that article. They also would not be able to say, for example, employees living within 10 kilometers of the workplace will never receive this leave for inclement weather because they can walk to work. They have to look at each situation and the specifics of each situation individually and consider them. It's more about the process they go through in making their decision than it is about the outcome or decision itself. And like I say, there's more complexity to that, but I think that's a pretty good foundation. Again, if you looked up the term discretion as a legal definition, it would probably give you some really good input on how to argue whether or not the employer has or has not exercised their discretion.
Okay, thanks. I didn't know if you had any other further thoughts or comments from either of you.
So I could just say, when I started my union work 20 years ago, I was working with a collective agreement that was over a century old. So it had started being negotiated in the late 1800s. Some of the language was really, really hard to navigate. But whenever I asked someone what my entitlements were, they said, well, read the collective agreement. If I'd had this tool then, it would have been a lot easier. You can really use this tool to plug in any kind of agreement language and sort through it. So I think it's a really valuable tool that should be shared with members for sure.
Yeah, absolutely. I would agree. And I would say that it's actually, even though it's part of our one of our main base, for lack of a word, basic courses in terms of the Talking Union Basics, I think it's a really underutilized tool. And for a lot of the folks on the call who are representatives, I think it's a really good stepping stone tool to help you build your argument for your grievance, because you're basically just clarifying for yourself that your member that you're representing has fulfilled all the conditions. And so what's the employer's problem and why aren't they giving the employee that right? And if you can map it out as clearly as that 4-step framework when you're making your arguments with the employer, I think you'll find it easier for yourself in terms of building that grievance experience. The only other thing I would say in terms of the bargaining process is, as we mentioned earlier, make sure that you are putting your input in when it's that time. But also in terms of exercising your rights to file grievances when you are having interpretation disagreements with the employer, because that's the way that the union builds its credibility when it says at the table, well, this article, the language really is confusing for obviously managers and the employees because nobody agrees on how it's supposed to be exercised. And those rights are there so that you can exercise them, right? Otherwise, we wouldn't have won them in the first place. Management would have just said no and continue to say no unless we assert, right? For folks who are in between agreements right now, please make sure you continue to always keep your information up to date in the member portal, because that's the way that we are communicating mainly with members. So this is home email addresses, home phone numbers, that home mailing addresses, right? So we won't be communicating with you through the employers' networks. And also, we will be dropping a survey after this. So we are encouraging you to please fill out these surveys. Let us know how these 1-hour sessions are going for you. It's kind of bits and pieces of some of our bigger courses. And until we can get up and running with our larger courses in this virtual world, it's really important that you're continuing to get union education this way. And we are appreciative of the fact that you've taken the time to make your workplace a better workplace by taking this on. And other than that, I thank Deanna for always being our support in the background and helping us with the back end for our sessions, and for Sharon for co-facilitating with me today, and for you all for taking your lunch and getting to know more information about your collective agreement. So thanks for that.
Thanks, everyone. Enjoy the sunshine.
Thank you.